Well, hello and good afternoon again. Welcome to the fourth in a series of bite-sized webinars discussing counterparty risk. Today's seminar is on freezing orders and will be given by Russell Gardner, who will be well known to many of you, and also by Rebecca Maddison, also well known within our team. In terms of housekeeping, for those who haven't been on before, in order to ensure the quality of the webinar, I'd be grateful if you could mute all your microphones and also keep your videos switched off. If there are any questions during the course of the presentation, please could you use the text function in the Teams toolbar. It's a bubble icon in the Teams toolbar, so you should be able to find it. If you could type in your questions at the end of the presentation, I'll direct the questions either to Russell or Rebecca as necessary. Please be aware the text function, it can be read by everybody, so can you please keep the text clean. We will be recording the presentation, so we can then pass it on to everyone at a later stage. If anyone has any questions at the end and they haven't asked them, they will of course be very welcome to call and pass them on to Rebecca or Russell, and they'll deal with them in due course. So now I'll hand over to Russell, and thank you.
Well, good afternoon all those who decided to join us live. We're going to cover in half an hour or so the basics of freezing orders. Rebecca's going to tell you about how you go about obtaining one and in what circumstances, what you need to prove, and she'll refer to some of the authorities. I'm then going to take you through a brief journey on one of my actual cases, which has involved a couple of outings to the Court of Appeal and a few other dramatics along the way, and to give some guidance on what you can do to enforce one of these freezing orders if you actually need to. Of course, a lot of freezing orders are complied with, and the main way in which parties comply are by putting up some form of alternative security, either making a payment into court or some sort of guarantee. So I'm going to hand over to Rebecca. She'll walk you through the bits and pieces, and I'll come in after she's spoken about those to talk about enforcement issues. And what we're going to do, we're turning our videos off so you can focus on what Rebecca was saying and on the slides, and not trying to work out what we've got in the background. Rebecca.
Thank you very much, Russell. Just going to, so the first thing we're going to look at is what is a freezing order. So it's an interim injunction that restrains a party from dealing with or disposing of its assets. And the purpose is to prevent the dissipation of the respondent's assets until judgment is either obtained or enforced. It can be sought pre-action or post-judgment. It's often sought pre-action if there are concerns about eventual enforcement post-judgment. It can also be sought post-judgment to preserve the defendant's assets until judgment has been enforced. The application is usually made without notice, and after it's been served upon the respondent, there is a return date hearing where the respondent can make submissions to the court. And following that hearing, the court will decide whether the order should continue or be set aside. Now, it's quite a draconian remedy, and it's been described as the nuclear weapon of the law. So we're going to have a look at the scope of a freezing order. Orders can be obtained in respect of assets either within the jurisdiction or worldwide. A worldwide freezing order is sought when a respondent doesn't have sufficient assets within the jurisdiction to cover the applicant's claim. We would, for instance, usually require a worldwide freezing order in the context of shipping claims, given their international nature. The scope can also be extended to cover assets held by third parties on behalf of the defendant. There are two standard exceptions to a freezing order, and those are that the applicant is allowed reasonable living and legal expenses, and expenses incurred in the ordinary course of business, which we will consider a bit later. It's important to note that the freezing order doesn't provide security or provide sort of any priority over any other creditors in respect of the respondent's assets. Its purpose is to preserve the assets. So we're going to have a look at the requirements for obtaining a freezing order. First of all, it's within the court's discretion. It's an equitable remedy. It originated as an equitable remedy, and it was brought into statute by Section 37(1) of the Senior Courts Act 1981. Given its draconian nature, the court will be guided by equitable principles and consider whether it is just and convenient to grant the order. Essentially, the order will be refused if the injustice to the respondent would outweigh the benefit to the applicant. And an applicant's conduct is taken into account. They must act reasonably and without undue delay, which means taking action as and when facts emerge. The applicant also has a duty of full and frank disclosure. The application is usually made without notice, and the applicant must disclose all matters that are material to the court deciding whether or not to grant the order. We're going to have a look at a couple of cases as examples. In the case of Irish Response Limited and Direct Beauty Products, it was held that the duty was to make a fair presentation of the material facts and the law relevant to the application. And in Brinks Mat Limited and Elcombe, the disclosure should be maybe matters of fact or law, and also might be adverse to the claimant. The duty applies to facts known by the applicant, but also facts that ought to have been known had proper inquiries been made. And a failure to provide full and frank disclosure can result in the order being set aside at the return date hearing. And we're going to have a look at some examples a little bit later. Now, in addition to sort of the equitable principles that an applicant must establish, case law has also established some general conditions for obtaining a freezing order. And we're going to focus on the four sort of main conditions which sort of can give rise to interesting issues. The first is that the applicant must have a cause of action, that is an underlying legal or equitable claim. The applicant must also have a good arguable case. They must demonstrate the existence of the respondent's assets and that there is a real risk of dissipation of those assets. The court will also require cross undertakings by the applicant, which we will also look at in a bit more detail. So the first requirement, the underlying cause of action. So the freezing order must be ancillary to a substantive claim which is subject to the jurisdiction of the English court, which the applicant must demonstrate. And I've put up there a quote from Lord Diplock in the Siskina case. So there must be a pre-existing cause of action against the defendant arising out of an invasion, actual or threatened by him, of a legal or equitable right of the plaintiff, for the enforcement of which the defendant is amenable to the jurisdiction of the court. So moving on to the second requirement, the applicant must demonstrate that they have a good arguable case, that is, that they have an underlying cause of action. This could be a counterclaim to a claim that the applicant that the respondent has already brought against the applicant, but it's not always as straightforward to demonstrate as it seems. In the case of the Niedersachsen, and I hope I said that right, the court considered that a case that is no more than arguable is not sufficient to be considered a good arguable case. But it is not necessary to establish that the claim is bound to succeed or has more than a 50% chance of success. We're going to have a look at the recent case of Phin Bank PLC and Investment Corp, which considers the requirement for a good arguable case and the applicant's duty of full and frank disclosure in respect of the full factual position and merits of its underlying substantive claim. So in that case, the English High Court discharged a freezing order at the return date hearing on the basis that the claimant did not have a good arguable case on the merits. The claimant, Phin Bank, did not reveal to the court the existence of a stock management agreement, which, on the facts, meant that the defendant had not actually caused the claimant's loss, but rather it was caused by a fraud by a third party. The court criticised the claimant's failure to provide full and frank disclosure of the facts relevant to the claimant's substantive claim. Once the full factual picture was actually revealed by the defendant at the return date hearing, the court held that there was no good arguable case on the merits of the underlying claim, and the claimant had failed to provide full and frank disclosure. And now we're going to look at the third requirement, the third main requirement, which is that the applicant must establish an existence of assets. And those could be assets either within the jurisdiction, if it's a domestic freezing order, or in specific countries or worldwide in respect of a worldwide freezing order. And in Ras Al Khaimah Investment Authority and Besfort Development, the correct test for assets that would be caught by a worldwide freezing order is whether the applicant has grounds for believing such assets exist, not whether the defendant is likely to have such assets. And in JSC Bank and Ablyazov, a case that we're going to see a bit later, sort of a later decision, the enforcement principle was established, and that is that the court will only grant a freezing order in respect of assets that would be available for execution of any subsequent judgment. So, what types of assets are caught by the standard form wording of the freezing order? Well, I put it up there. That's Practice Direction 25A of the Civil Procedure Rules, also Appendix 11 of the Commercial Court Guide. And it's all the respondent's assets, whether or not they are in his own name, and whether they are solely or jointly owned, and whether the respondent is interested in them legally, beneficially, or otherwise. For the purpose of this order, the respondent's assets include any assets which he has the power, directly or indirectly, to dispose of or deal with as if it were his own. The respondent is to be regarded as having such power if a third party holds or controls the asset in accordance with his direct or indirect instructions. The text highlighted there in red is the additional standard wording for a worldwide freezing order. So the wording's pretty broad, and it can cover all types of assets, including bank accounts, shares, property ships, and also as far as Bitcoin and cryptocurrency. But it's not always straightforward, as much as dependent upon the respondent's interest in the assets. And we're going to have a look at some specific examples where the respondent's interest in the asset is not always entirely clear. So what if the respondent to the order is the sole shareholder of a company with many assets? Can the applicant freeze the company's assets under the standard freezing order wording? This was considered by the Court of Appeal in Lakatamia Shipping Co Limited and Nobu Su et al, and that is actually one of our cases. The worldwide freezing order in that case contained the standard wording, and at the first instance hearing, the question arose whether the freezing order had the direct effect of freezing the assets of 3 companies, of which the first defendant, Mr. Su, was the 100% shareholder, but which were not defendants to the claim. Now, the judge at first instance held that the defendant's assets included any asset which they had the power, directly or indirectly, to dispose of or deal with as if it were their own. The defendants were to be regarded as having such power if a third party held or controlled the asset in accordance with their direct or indirect instructions, so that the freezing order had the direct effect of freezing the assets of the 3 non-defendant companies. On that basis, Mr. Su was ordered to give Lakatamia notice of any proposed dealings with certain assets of the 3 non-defendant companies. The defendant appealed. The Court of Appeal, in dismissing the appeal, did not agree with the judge at first instance and held that the company's assets belonged to the company and not its shareholders. However, since the freezing order restrained the first defendant from diminishing the value of any of his assets, which included his shareholding in the company, it would restrain him from procuring the company to make a disposition of those assets, which would likely result in a diminution in value. Therefore, while the Court of Appeal considered the judge at first instance was incorrect in finding that the 3 companies' assets came within the standard wording of the freezing order, he had been correct to conclude that the freezing order covered dispositions relating to the assets of the 3 non-defendant companies. However, following the Lakatamia decision, the Supreme Court in JSC Bank and Ablyazov in 2015 had to consider whether the right to draw down under a loan agreement was caught by the terms of the freezing order. The respondent had no legal or beneficial interest in the loan agreement, and therefore no enforcement measures could be taken against the asset itself. The Supreme Court decided that the proceeds of the loan agreements were caught by the freezing order on the basis that the respondent had the power, directly or indirectly, to dispose of or deal with as if it were his own. Following this decision, assets can include assets which are not legally or beneficially owned by the respondent, but over which it has control and the power to dispose of or deal with. This causes potential tension with the decision in Lakatamia. Does it now mean a standard freezing order can extend to the assets of a company of which the respondent is a sole shareholder or director? The position was somewhat clarified in the subsequent decision of the High Court in FM Capital Partners and Marine, where it was held that Abli Azov had overruled Lakatania, but only on the question on the proper interpretation of the standard freezing order wording. The assets of a wholly owned company are still not caught by the standard freezing order on the basis that the respondent is acting as director of the company in exercising power over the company's assets, but not in his or her own right. So where does this bring us out? Well, there are limited circumstances where a freezing order may be found to apply to assets of a non-defendant company wholly owned by the respondent, i.e. only where the company's assets are effectively the respondent's assets. On the basis of the standard form wording, if an applicant wants the order to cover specific assets, they should be put before the court and the draft orders should contain suitable wording to cover these assets. We're now going to look at the fourth requirement, which is that the applicant must demonstrate that there's a risk of dissipation of the respondent's assets. And generally, the applicant must show either there is a real risk that the judgment will go unsatisfied and that the respondent will dissipate or dispose of his assets other than in the ordinary course of business, or that assets are likely to be dealt with in such a way as to make enforcement of any award or judgment more difficult. That's just an example of somebody throwing their money away. So the court will consider objectively whether there is a risk of dissipation, taking into account all the circumstances. It's not necessary to show that the respondent intends to deal with his assets so as to defeat the enforcement of any eventual judgment. The court will consider the effect of the respondent's actions, not his intent. And relevant factors that the court may consider, I've put a few up there, are things such as ease of enforcement if assets are overseas, any previous defaults by the respondent, evidence of dishonesty, and the ease with which assets can be moved out of reach. We're going to look at this in the context of a recent case, which is Les Ambassadors Club Limited and Al Bluey. This is a recent case that demonstrates not only a failure to establish a real risk of dissipation, but also a failure by the applicant to provide full and frank disclosure. At the without notice application hearing, the claimant casino obtained a worldwide freezing order against the defendant customer, Sheikh Al Bluey. The claimant relied on the defendant's alleged lack of commercial probability, including defaulting on debts and breaking promises. Their argument was that the defendant had gone to ground in Saudi Arabia in the middle of his default in respect of gambling debts, and there was a concern that he would seek to remove all of his assets to Saudi Arabia, where they would not be able to enforce. However, the court set aside the worldwide freezing order at the return date hearing on the basis that there was actually no real risk of dissipation. The defendant's return to Saudi Arabia coincided with his annual return to the country. The defendant had substantial assets in London, which were contrary to the claimant's arguments that he would remove all personal assets to Saudi Arabia. He also owned assets in sums more than sufficient to discharge the debts in jurisdictions where enforcement was possible. And furthermore, he had a history of dishonoured checks at the casino, but ultimately he had always made payment. Therefore, the court considered that there was no real risk of dissipation. The court also found that there was material non-disclosures by the claimant casino, as they failed to give a fair presentation to the court of the real risk of the dissipation of the respondent's assets, which highlights the need for full and frank disclosure. I'm going to briefly look at the cross undertakings that the court may require of the applicant. So the court requires the applicant to give certain undertakings which are contained within the body of the freezing order. The extent of the undertakings will depend upon the nature of the claim and the applicant, but may include providing security for an undertaking to pay any damages that the respondent incurs as a result of the freezing order. Russell and I have actually had a case where the amount of the cross undertaking in damages was $100,000. And I've put up there Practice Direction 25A of the CPR, paragraph 5.1, which contains the sort of standard undertakings required. Going to briefly look at the two exceptions to the freezing order. So the standard form exceptions to a worldwide freezing order over all assets allow, first of all, the applicant, the respondent, a reasonable sum for living expenses, legal advice and representation, and also to deal or dispose of assets in the ordinary and proper course of business, such as paying employees or trade creditors. The respondent has to inform the applicant where the money has come from for legal advice and representation. We're now going to have a look at, we've now got our worldwide freezing order. We're now going to look at what the respondent is required to disclose in terms of the details of their assets, which is crucial to the effectiveness of a freezing order. The respondent is usually given a short time, let's say 7 days, to prepare an affidavit setting out the nature, value and location of the assets. There is a de minimis limit where nominal assets need not be disclosed. However, the extent of the obligation is less evident. I'm going to look at the case of PJSC Commercial Bank and Kolomoisky, where the court considered the meaning of value, location and details of assets in a worldwide freezing order. The claimant considered that the responsive disclosure provided by the defendants was inadequate, as it failed to provide information regarding various identified choses in action, that is, the right to sue third-party debtors, thereby rendering the claimant unable to analyse whether it needed to take further steps to police the order. The claimant therefore applied for an ancillary asset disclosure order. The defendants argued that the disclosure they had given was sufficient to enable identification of all relevant debtors, and the claimant was seeking excessive, wide-ranging disclosure that went to the substance of the claim. It was held by the court that they had jurisdiction to make an asset disclosure order where it was required to enable the claimant to, 1, identify the nature and extent of the respondent's interest in the assets, and 2, assess what further protective steps it should take in order to be able to police the order. The court considered in this case that the claimant's application went beyond what was required in the context of the choses in action, and disclosure was not necessary to enable the assessment of the extent and nature of the defendant's interests in those assets. I'm now going to hand over to Russell, who's going to take you through enforcement of freezing orders and remedies for breach.
I've chosen what I consider to be the 3 most important elements to a freezing order to talk to you about in the context of enforcement: penal notice, asset disclosure and expenditure restriction. Penal notice is all important because of the very serious consequences which can follow from breach of a freezing order, i.e. at the most serious contempt, which I shall come to. The order must display prominently in large on its face, in bold letters, spelling out what might happen, otherwise it isn't enforceable. The relevant practice direction provides that disobedience of an order restraining a party from doing an act or requiring an act to be done is dealt with by contempt and other proceedings. And notice there's something like this: if you, ex-defendant, disobey this order, you may be held in contempt of court and sent to prison or fined, or your assets may be seized. And it goes on to say, refers to other people, any other person who knows of this order or permits the defendant to breach the terms of this order may also be held in contempt and may be sent to prison, fined, or have their assets seized. I'll come back to any other person because the third party element is quite important. The reason why it is such a serious sanction is that breach of a court order such as this is considered to be an attack on the administration of justice. And the courts do expect their orders and their judgments to be respected and complied with as a matter of public policy. The penal notice is required not just for procedural purposes, but because of what it says and what it threatens, it's also designed to encourage parties to comply. And it is quite intimidating to receive such a notice. On the third parties that I've referred to, it's common practice to notify any other relevant or involved party. But you need to note that these freezing orders, albeit that they might be termed worldwide, are not automatically enforceable in foreign jurisdictions. One needs to apply to a local court for an order that the freezing order be recognised in that jurisdiction. I'll come back to third parties and how they can be drawn into the net later on. The second element is asset disclosure. And it's one of the principal advantages of a freezing order that you can require a respondent to give details of his or her or its assets. And that's a very important weapon, which goes to the heart of the application, which is to identify where assets are, to seek to preserve them, and ultimately to enforce against them. And it's especially useful, of course, if you actually do have a judgment in your hands. And in a recent case, it has referred to the freezing order acquiring post-judgment an enhanced role as an aid to execution of that judgment. The third element I'll refer to is the expenditure restriction, and Rebecca has indicated the liberties which a party subject to a freezing order may have. But if you're faced with somebody who, for example, is in breach of a freezing order or in breach of other orders of the courts in the proceedings in which you're involved, it's sometimes possible to have those restrictions released. In other words, you have them removed so that someone is not allowed to expend money on his business activities, and thus you prevent the respondent from carrying out transactions even in the routine course of business. Clearly, a balance has to be struck because you don't want to bankrupt somebody, you want them to continue to do business. But if someone is flouting orders of the court and breaching the freezing order, there are these measures that you can take. So you have that liberty removed. And it's certainly possible in the case of somebody who is a serial contemnor, or indeed a judgment debtor who's refusing to pay the judgment debt. The idea always is to apply pressure to get the respondent, the defendant, to pay up and not to punish for the sake of it. The principal remedies for breach, starting with the most serious, is committal, or a fine, or a seizure of assets, or procedural sanctions, which I'll come to. On a committal, the maximum sentence is 24 months, and in my case, I've had the respondent committed for 24 months in relation to various industrial scale contempts. Again, I don't want somebody to go behind bars to punish them. There's an element of punishment. The court will always take into account the penal aspect of an order to commit somebody, but they also take account of what they call the coercive effect of a committal, and that is to try to persuade the person who's behind bars to pay up or to comply. Just en passant, when I say contempts on an industrial scale, they included failing to disclose interest in a property in Monaco, which was subsequently sold, and the 27 million euro proceeds were dissipated, purchasing a diamond ring for a relative, spending money on a documentary film about the defendant, which he thought that the world may be interested in which, for example, he boasted about some of the assets that he was seeking to hide from us. Lesser sanctions, fine, or seizure or sequestration, as it's called, of assets, they are lesser remedies, but of course a sequestration is only effective if assets are there to be seized. I've mentioned these sanctions in the context of individuals, but they of course can also apply to corporations, particularly the fine and the sequestration, and certainly committal can apply in relevant circumstances to directors or officers of a company. And last and least, as it were, procedural sanctions, simply, for example, that somebody can be debarred from, for instance, serving a defence if they haven't complied with a disclosure order. In the case I'm talking about, we obtained judgment in a rather large sum of money, having previously obtained a freezing order, but we had no success in persuading the defendant, who steadfastly remained outside of the jurisdiction, to pay up or to comply with the terms of the freezing order. And he stayed away, he stayed abroad until January last year, when he presumably thought that the coast was clear. But I had in the meantime obtained a passport order. Now, these are orders frequently issued in family proceedings where, for example, abduction is feared and a party has his or her passport seized to prevent them from travelling abroad. But in my case, I invoked what is my favourite statutory provision, which is the general power of the court under section 37(1) of the Senior Courts Act to grant such injunctions in all cases in which it appears to the court to be just and convenient to do so. You've got to establish, this is serious stuff, you've got to establish somebody who's continually evaded court orders, who's not complying with a freezing order, breaching its disclosure obligations and or dissipating assets. In other circumstances where, for example, you have a defendant, a recalcitrant respondent who is in the jurisdiction, it's possible to apply for what is called a bench warrant. And that is something where a procedure whereby you obtain an order from the judge, which requires, it results in the arrest of the person and requires them to attend at court to be cross-examined as to their assets. And we're back to my man. He was met on the plane at Heathrow when he arrived last year and presented with the passport order. What that required him to do was to surrender his passports, he had more than one, to provide an address at which he was going to reside and to make himself available to be cross-examined as to his assets. I've mentioned on the slide there the relevant provisions that you can read. He was required to provide disclosure of various documents which we identified within 21 days and to swear a revised affidavit detailing all his assets worldwide, which are worth more than 10,000 US. He told police he was staying at the Dorchester, which was found to be untrue. In fact, he tried to do a runner by taking a taxi to Liverpool and getting a ferry across to Belfast to try to flee the jurisdiction. Picked up by the police, however, at Liverpool, and a port alert was in place as part and parcel of my passport order, and he was brought back to London. He was subject to reporting restrictions, has to report to the police every day, and was then brought to the court to be cross-examined as to his assets and to provide disclosure. I should say also, and I mentioned here other remedies, where someone is not complying with their disclosure obligations, it's sometimes possible to obtain a search order, was called the Anton Pillar, and we've done it in relation to not just physical documents, but also electronic documents and email correspondence and social media accounts. That's what I refer to as a cyber search application. And we've also got an order to conduct a premises search. So this chap who's residing in London, we got a search order enabling us to go into his premises to seize all the hard copy documents that were there, plus mobile, plus laptops, etc., and to download the material therefrom. That's obviously outside the scope of this webinar, exciting though it is. But what is relevant is that to this webinar is that during the course of this process, these search applications that we executed, the defendant revealed that a number of other third-party people and entities who had notice of the freezing order, who were given notice of the freezing order, had assisted the defendant to breach the freezing order, in particular in relation to the dissipation of the Monaco proceeds. And that gives rise to a cause of action against those third parties in tort. And there are two bases for that. The first is what's called the Marex jurisdiction. It's quite novel. It's a 2017 case. In fact, the substantive case, the decision was published yesterday by the Supreme Court, but that related to the substantive proceedings. What I'm talking about is an application that was made fairly early on to serve out. And in the context of that application to serve out, it was held that there's a good arguable case that English law recognizes this tort of inducing or procuring a violation of rights under a judgment. It's somewhat analogous to interfering with a contract unlawfully, but there it is, and that's a jurisdiction which we are relying on. And the second ground, the second tort, is a much more well-established principle. Unlawful means conspiracy. Basically, if there's an agreement to use unlawful means to injure a claimant, one can be held liable. And the case that I've referred to, the Abliazov case, is relevant because it held that the contempt of which we say these third parties are guilty counts as the relevant unlawful means. So, as I say, the freezing order has led to various other consequentials, and what it's done also, it's drawn other people into the net in relation to the proceedings and the judgment which we're trying to enforce against a recalcitrant debtor, a serial contemnor who's doing his damnedest to hide his assets. So we brought these other people in and not just joined them to the proceedings, but also issued freezing orders against them. And so it goes on. And that brings me to the end of the presentation. I shall go back on camera, which I hope you found useful. And I wonder, Tony, whether anyone has any questions.
Thank you, Russell and Rebecca. Yeah, no questions, I'm afraid to say. So I'd like to obviously thank both of Russell and Rebecca for excellent presentations, very detailed and interesting. And to remind everyone that next week we have the last of the present series, which is going to be called Jurisdiction and Commencement of Arbitration. So please could you all join us again next week, Thursday, the same time. Thank you very much.